Well, I'm pleased to be here, and thank you for sticking through it. I'll say I think we fully realize that we're the only thing standing between you and a good stiff drink and dinner. So we'll try to keep it a little bit lively, and also we will try to be expeditious. So what I'm going to talk about, and I think we have. Let's see here. Yeah. Okay. So there are four themes, and we just kind of canvassed them, but I want to hone in on an important set of developments that are going on that are transforming really how we think about information assets. And we talk about IP a lot, but I think you can cabin yourself too easily in certain legal categories. You need to think about IP as a strategic asset, and it really a lot of times becomes what you're dealing with information, and you're dealing with the strategy with approaching a variety of forms of IP. So what we do in our treatise, and also when I've taught, what we try to do is we try to get people to focus on really the importance of the commercial aspects of IP. We deal with IP in terms of litigation, and technology in terms of litigation. We deal with it as a separate category in terms of getting protection. But really what you're really being asked ultimately, and we heard great presentations in the last panel on value and the drive on commercial side, but that's something that we as lawyers need to be thinking about too. What is it that we're really doing in order to help our clients realize ultimately commercial value out of this asset? They're not doing it for their health or just for your benefit or intellectual curiosity. There's a reason behind it. So you need to think about what that reason is. What I have found increasingly is, especially, and this happened back, I've been doing this for 38 years, so I've seen a lot of ebbs and flows in terms of the way the practice has gone. But what you see is across international boundaries now, especially, the trade in information assets has been explosive. And how that's approached and what you do as lawyers and what you have to think about as lawyers is not just necessarily confined to your particular jurisdiction. You got to think about it in a more global sense. And we'll talk a little bit about that. And what's come up is basically an information law merchant. And the question I ask, and I'll get to, I hope, at the very end briefly, is UNICATRAL, which is a UN body that deals with commercial treaties and model laws and legislative guides, has been considering whether to take up a project that would deal with international commercial transactions on IP. And I'm going to ask the question, I think from a policy standpoint, I'm going to hold off to the end, but it's something, at the end of the presentation, I think it's something for us all to consider as lawyers whether that would be a good idea. So with no further ado, let me talk a little bit, give some data and some ideas about what is driving and what's very important about international transactions in IP. If you think about it, and there are lots of studies, especially in the United States, you got a variety of studies have been done on the value of information transactions in IP. And in the United States, we have shipped out a lot of the manufacturing, we've done a lot of other things. What we really are is more and more an information economy, broadly conceived. In fact, there was a study by the U.S. Commerce Department, and according to the U.S. Commerce Department, about $6 trillion, about over a third of the GDP is attributable to information asset-intensive industries, directly or indirectly. That's a huge number. That's a lot of money. That's a major part of our GDP. 30% of our jobs are directly or indirectly related, and that's just increasing, accelerating through time. That's one measure to think about it from a U.S. standpoint, but if you think about it from another standpoint, which is really dramatic, you see it in China, you see it Asia Pacific, you see it all over. You see it in Europe, you see it all over, is a focus on how to commercialize, monetize, and transact in IP assets. And one of the indirect proxies that I cite for this is that from 1983 to 2003, global export of goods grew by 20-something%. But if you look at it, it quadrupled. In the same time frame, the royalty payments that are done with respect to information assets have quadrupled on a worldwide basis. This graphically shows that sequence, and you can see it's a geometric sort of progression, at least towards a part of it. And so if you think about the importance of IP transactions, and if you use as an indirect proxy royalty payments, and not everything's going to result in a royalty payment, but if you just think of transfer payments as one measure of commerce, that gives you a pretty good idea of what's happening across boundaries. So what we have argued in our treatise, and what I think we've argued in a variety of other places, is that really the commercial IP transactions are unique. We have sales of goods, we have leases of goods, we think about secured transactions, we think about payment systems and the like. Well, really, IP transactional law is a discrete body of law. And the reason why it's discrete is it's really formed by three influences. The structure of it, the DNA of it it reacts to the underlying IP. You have to design the transactions around the contours of the IP and the information asset. It is not sufficient just to say I'm going to have a contract about it. You have to think about the impact on the IP, but also the limitations of it. It's also formed by public policy limitations. It used to be very true in the United States that antitrust law played a significant role with respect to what you had to do in structuring your transactions. It is still true, but it's less so in many transactional formats, because the Justice Department takes an approach that rule of reason generally will apply. But in the EU for sure, and certainly in China and other places, public policy limitations have a much bigger role to play in terms of the licensing transaction. It comes as a surprise to U.S. lawyers when they start to do international deals that there actually are rules with respect to what type of business deals you can cut. And then finally, but most importantly, the core strand of the IP commercial law is contract. Licenses, for example, assignments, they're contracts first and foremost. And you get a lot of courts, a lot of arbitrators, a lot of other people increasingly coming in who aren't necessarily IP specialists, who are construing and thinking about the IP contracts in a commercial sense. And so you have to be very familiar with that. Okay, so basically, what I call information law merchant. Now, since I'm somewhat pedantic and I'm old, I'll just cite generally what you think about commercial law generally from a Western standpoint, admittedly, is that it had its origins in in trading empires that were between the Phoenicians and the Greeks. And any great trading empire had, when they dealt with other people, had to devise various ways to transact business with each other. In the common law, certainly, and also European law was informed by basically law merchant, which was an informal body of principles that would be applied and be enforceable as against merchants who were trading across boundaries. In order to get your goods from one place to another, in order to have them sold, in order to be able to get your money, you had to have some sort of enforceable body of law. And it really was not law as we think about it. It was a lot of practice. It was enforced by merchants. Well, similarly, I won't go too much further to draw the analogy or the metaphor, but that's effectively what we have across national boundaries now. We're doing more and more trade, as I talked about before. It's increasingly important to developed countries as well as developing countries, these trade and information assets, and we deal with each other across boundaries all the time increasingly, because the barriers to technology have greatly and vastly reduced. And now what we have is we have a lot of ourselves. We deal with each other across boundaries. We strike deals because it is a commercial enterprise. And yet a lot of the principles, a lot of the concepts, which are somewhat common, are a little bit open. And a little bit, there's kind of a lore, a lot of experience, long contracts, a lot of detailed negotiating that you don't necessarily see in other commercial areas, like, for example, in the sales of goods. There are some common legal principle approaches, but they're kind of known to specialists. So I'm going to talk about a couple of examples, because we don't have that much time, and you don't have that much patience, for me to go through all of these slides in great deal of detail, but I'm going to bring up a few examples which you would think lend themselves to an international approach to common principles. I'll cite one. The first one is huge issue. The problem of international supply chains. So now what you have is vast trading that occurs in what will ultimately, let's say, become a good. Let's call it a car, which I'm going to use that as an example specifically. A car right now, and we represent car manufacturers, a car right now is not manufactured in one plant like it used to be in the Ford plant in Detroit. There are parts that come from all over the place. Same with smartphones, same with computers, same with all types of assets that are laden with IP rights. They come burdened with a lot of IP rights, and you transact across boundaries. There was a case in the Supreme Court, it was just decided, an incredibly important case, that dealt with the issue of could an IP owner at the very top of the chain, when they supply something, could they put restrictions on what was done with that product that was authorized, that they authorized to be sold? Could they put a use restriction on it? And this involves toner cartridges. Could you put a use restriction and require your distributors to impose those restrictions? And if someone knew about it, that downstream, an ultimate user, would the IP rights flow down such they could come down and get another toll charge or limit the use? Now this happens a lot. This happens a lot in IP industries. You guys know a lot about market segmentation, where you might very well want to split up and get different values out of different distribution chains. Supreme Court of the United States said that exhaustion applies if there's an authorized sale. Now, it also said, surprisingly to many people, is that we're not going to have, you can't, you have a whole series of suppliers. You think about that, they're coming from all over the world. And if every one of them entered into and said, we're going to be a restriction here so that ultimately I can come down that user as you're driving down the road, you're an infringer. And in one of the examples that was brought by, I think it was Intel, I think it was in their briefing, they gave the example of diapers. I didn't realize this until I read the brief, that diapers are covered by about 1,500 to 2,000 patents in a given diaper. Smartphone, 250,000 patents. But, so they raised the point, well, what if you go over to Europe and you're buying diapers and you're bringing to the United States? Are you an infringer? So, they made it a very prosaic example, but it's a very interesting problem because the law in the United States was, yes, you could be. That's what the Federal Circuit had held several years ago. And so the issue is not that you would necessarily sue all the users, but you were able to put downstream uses. You could put restrictions at the very top that would flow down through the chain, a property-based approach. Supreme Court said, no, we're not going to do that. Both domestically and internationally, if the sale is authorized, if there's an acquisition, you can't have an effective restriction as a matter of patent law. It can be, as a matter of contract law, potentially, they can get privity, but as a matter of patent law, you can't sue someone for infringement who bought an authorized sale. Now you think, well, that seems to be self-evident that there should be a limitation on the restraints and alienation. But a whole industry, all types of IP laden assets were built on the idea of segmentation and limitation, and to being able to have enforceable restrictions so that you couldn't necessarily sell in the United States something you bought over in Europe because you priced it saying, look, I'm pricing it for this particular market. I want to have a separate market over in the United States and I'll get a different price. They're different markets completely. You see that in the pharma industry. You see it in a lot of industries. So the concept is now changing. Now, the issue is, though, even after the Supreme Court case, what is going to happen increasingly is we've got to think about what is the product. And this is where I started at the very beginning. You've got to think about the assets that you're dealing with and think about the strategy. So for example, say I'm Tesla and I sell you a car, a quote car. Is that the product? Well, might be. But they also think about it in a different way. As you're driving that car down and you plug it in, you very well will get downloads that'll change some of the performance characteristics. It's an update. And that sound a lot like software? And then it sound like a lot of, you could get a maintenance fee. You could have a separate concept about how a product will be conceived in separate transactional pieces. So we have a conflict, if you will, or a tension, I shouldn't say conflict, a tension between the demands of international commerce and the desire to have, a deconstruction of the product. And this is what we as lawyers can bring to bear. We bring the legal talent, but also think about it from a commercial standpoint. How is it that your clients might be able to work around exhaustion principles? But from a policy standpoint, I'll just and then I want to go on to a couple other examples and then wrap up. From a policy standpoint, wouldn't it make sense for there to be, because of the global supply chain, because of the movement in transactionals in IP, to have some common concepts around what exhaustion means and when it would apply? Maybe. It certainly would help if we really want to have international trade, not only, and I picked cars for a specific reason, it's not only when you're licensing your copyrights to a movie or you're licensing trademarks, you're thinking about that sort of thing, but think about it from the standpoint of the prosaic good. What happens because their goods are laden. Now, with all types of IP, now car companies and everyone else is racing for the inside of the cabin. It's not a car anymore. It's an entertainment unit, on a drive chain, right? So you have to think about, what you're selling in terms of a product and how the IP works. Okay, so there are other issues here. As we were talking this through, I was at Unicatral, they asked me to be a chair or moderator or whatever of a presentation to one of their study groups on whether it made sense to have some international principles, formal international principles, recognized across boundaries. They did that with sales of goods, they have it with secured transactions, they had a variety of contexts, because it is a basic commercial law body that hopes to foster international trade. So we went through and we talked about some of the issues in our information law merchant. When I deal with people, experienced practitioners across the world, and we're dealing with a problem or a contract, you have to ask yourself, okay, well, what are the principles that are going to be applied here? Now, part of it's going to be choice of law, and you fight over choice of law. Should it be here? Should it be there? Should it be someplace that no one knows what in the heck the law means, and they'll just figure it out later? There are all those type of questions that go on. But basically, when you get down to enforcing it, and this is the enforcement part of it, you've got to understand is your deal going to be respected? Is your deal going to be respected? And if you have different approaches on basic commercial principles, you have to wonder yourself whether you're creating a barrier to trade that makes any sense at all. So from a policy standpoint, as you think about this, and in any one of your jurisdictions, these are the type of issues that will come up. Do I have to have, is there a special rule in IP that deals with what exclusive means? When I wrote the chapter on exclusive licensing in our modern licensing law book, I was stunned, absolutely stunned. I thought I knew what exclusive meant. I didn't. Not even in the United States. And when you do it on an international comparison, it's even more cloudy. Exclusive can mean a lot of things. It could mean that the IP owner can't grant additional licenses, but they can use it themselves. Or they can have outstanding licenses that would cabin in your rights as your grant exclusivity. Another one is, can I enforce it? I'm the exclusive licensee. I have the most at risk. Can I enforce this IP right? So there are some of that's going to be governed by IP, but some of it's going to be governed by other principles that you got to think through. I'll quickly go through the last couple pieces here. Performance term, implied terms. What is implied in the contract that's not completely integrated? And so I'm going to conclude with the following thought experiment. As you think about what you do, especially on the commercial side, how you commercialize, drive value for your clients in their negotiations of their contracts. Think about what happens when you sit down and they have an international business, or they rely on international suppliers. What is it? How comfortable are you? And how many different people do you have to hire with respect all through the supply chain to figure all that out? Should there not be some common principles to think it through? And that is what I think Unicatral should really be studying, because actually, as I said before, information assets are at the core of the modern world economy. And on that, I'll end.
Well, thank you very much for your presentation. It was really interesting how you highlight the topic, and we'll be having a short Q&A, which is topic related and might be a bit better to organize, because all the questions are fresh and you don't need to hold on to them. after the session. So, anyone has questions? Yes?
How realistic do you think that this would be a separate body of law, since it ties into 153 countries in the world having their own different? I'll repeat the question. How realistic do you think that getting this recognized as a kind of international body of law, separate from other bodies of law, since it requires more than 100, I think 153 countries being part of the WTO, accepting quite some fundamental changes in their bodies of law, their IP laws, which somehow depend, at least in continental Europe, the IP laws are not a standalone body either. They tie into the civil code.
Mm-hmm. Yeah, so the question is how difficult. And so the answer is, no less or more difficult than getting all those countries to agree to TRIPS. So it's yes, it is going to be difficult. The thing that'll make it easier, though, and this is something that I think that we lose sight of, when you deal with a property right, we call this a good. Well, it just happens to be, if I look at it from one standpoint, I'm just getting plastic and some chips in it, and that's just one good. That's a property law that I deal with. I sell that good. Right now, there are principles that apply across, and countries have agreed to conventions that deal with transactions across that. The second, and so we deal with property right now. IP, we think of as being somehow, super, special, and it is in some ways, but it's not in others. It is, from a commercial standpoint, what is going to be driving your terms are the special part. We talked about value versus price, or the last panel did. But when you really look at it, yes, it will be somewhat difficult, but you don't necessarily have to have an enforceable body of law. There are other ways to do it. Well, some of the things that UNICOTRAL does is they come up with model law. Sometimes they come up with just a legislative guide or general principles that people use as kind of guideposts of how to navigate around. In the United States, we do that in a lot of ways too. But I'll never forget what I gave a speech one time on a commercial topic with a guy who actually knew Carl Llewellyn, was his assistant. And Carl Llewellyn was the architect of the Uniform Commercial Code in the United States. And so it had to be passed by all these state legislatures. And as difficult as we might think 153 countries are, I can tell you 50 states is almost an impossible task, right? And so someone asked him, said, Professor Llewellyn, why is it that we even need this uniform law? I mean, we kind of all do these transactions anyway, why do we need it? And he said something that's very, very important. He said, because of the case head notes. Now, what does that mean? The digest of the cases that had accumulated over time, you could not really know what your contract, how it was going to be interpreted and enforced. So the reason why to do something like this is sometimes explanatory power to help people navigate and not just to compel. And so what we had originally proposed, or the concept that we're talking about, would not affect IP law, would not affect public policy. We're not going to tell states what to do with their antitrust policy, which varies quite a bit and will affect the contract, but just general commercial principles. And general commercial principles apply to property anyway. So yes, it's difficult, but it's not impossible. It's been done quite a bit. That was a long-winded answer to a very, very direct question.
Well, thank you very much. Someone else has a question?
Does anyone so intimidated they don't want to ask a question now? Oh, this guy's going to talk forever. He's just going to take the oxygen out of the room.
Well, we have one brave person over there, no?
Yeah.
Do we then need an international court to decide on the matters?
Great question. So that's a great question. So UNICOTRAL has made they've made a general arbitration. They've come up with general arbitration principles. They've come up with principles concerning, for example, secured transactions that would apply, so that you could do financing over multiple countries and not have to know that you can go and get your collateral and that sort of thing and lend effectively. So there's lots of controversy because everyone has a different approach to how they deal with creditors and the like. And what the general approach, and I would think it would be here too, is that you, just like with licensing law is not a subject of federal stuff in the United States. It's contract. It's state. So we would not think that there would be some sort of supervening judicial body. Really, this is more like a sales of goods or in civil code, dealing with transactions generally. How do you approach them? And this is a unique body of commercial law. It's just as unique as sales and leases and secured transactions. But it is, again, that you have courts enforce that in the local jurisdiction. So I would not think that you would want to do that. And you see what comes up is like on the conventions on sales. You have cases that cite that, and then they're put into a digest so other people understand how other courts are looking at it. But you could not possibly create a world court on this. But the idea again is, from a commercial standpoint, commercial transactions, not consumer, not dealing with consumers. That's treacherous waters there. But you could have it, and you could let the local courts enforce it. But that's a great question.
Anyone else?
You briefly mentioned the Lexmark case and patent. Sorry. Yeah, you briefly mentioned the Lexmark case and patent exhaustion,
Yes.
and you just mentioned the fact that how you could potentially get around the exhaustion principles based on Lexmark. What are some of your ideas for that, other than contract, I guess, with your particular customer? But
So, sorry about that. No, don't worry, I'll get it later. Okay, all right. So I'm throwing my smartphone down just for that question. I'm out of anger, a fit of anger there, right? Or maybe just leapt out and just decided to kill
That's a
itself.
good way to
It's your IP stack.
That's right, my IP stack.
to overcome exhaustion.
That's right. So there's maybe 100,000 patents on this part and about 20 on that, and so deconstructing the product. Basically, the Supreme Court, if you read the case and you look at the history, this has been a real struggle in U.S. IP law, patent law, of exactly what you can do and different visions of what that law are. And so there will be cases that are going to come up where people are going to test this boundary. And I got a slew of them after I made some comments and I did some things. So the way we look at it, or the way I look at it now, is without knowing how it is going to turn out. If you read the case, Justice Roberts gave a full-throated, actually surprising given the questioning during the oral argument, gave a full-throated, very broad view of exhaustion and not try to end around it. So that he basically said, yes, I realize that you want to try to put restrictions, but as a matter of patent law, restrictions on an authorized sale are not going to work. Fine. But what that doesn't deal with is, like I said before, what is the product? So just not even as a matter of contract. Question is, what is it that you are selling? And so when I now get it's easier, a heck of a lot easier for GE, for example, to sell, say, oil field service products that come bristling with sensors and data collection and that sort of analysis. But if you think about it in a deconstructed way, if you try to separate out what it is the various stacks are within that, then maybe, just maybe, and that would have to inform your IP strategy. It had to inform how you do your patents. It had to inform how you structure your transactions and how you structure what you're, quote, selling to people, offering to them. But if you think about it in a segregated way, there might be some ways to deal with the problem. Now, or deal with Lexmark. Now, I say that provisionally because this came up when Article 2, I was an observer when they were going to revise the uniform law in the United States that relates to sale of goods. And this was back in the 90s. So the question that came up, because people could foresee this, they say, well, wait a minute. We were going to separate out information transactions from sales of goods. And the sales of goods lawyers started realizing, they said, well, wait a minute. If we really think about this, what prevents you from essentially saying that a car is nothing but a computer and it's all an information transaction? And it really is, this is still a good ultimately bought. So from the standpoint of the customer, they're buying this. From the standpoint of what goes into this, like when you sign up for a license through Microsoft, when you have to download that, you're not buying you're getting a license with respect to that particular component. So that's what I'm saying about deconstruction. That's one way to analyze it. There are a variety of others. A variety of other ways to look at it. There are a variety of other ways to look at what you're doing in a transaction too when you're talking about branding. When you're talking about copyright-related things. So an effective IP strategy, commercialization strategy, is going to think about this in a deconstructed way. Think about the variety of ways that you might be able to approach this product and not think about it in one linear way. And not think about it, okay, this is just, I'm going to file a patent and that's the way it is. There are other protections that you can have. Fashion industry is a good example that has dealt with, very limited IP protection in a lot of ways, but has come up with very clever ways to think about its product too.
Any more questions? So actually, I have a question, if
Sure.
I may. So
I'll try not to throw anything at you.
okay. Well, working at IMEC, we are actually making IP layers and stacks for products that we are transferring in a tech transfer agreement. So we take a product, we totally deconstruct it, and for each asset or segment of the product, we are trying to see what is useful for our company and what we need for doing further research, but also furthermore what the other party needs. So you're layering your IP stack, and you map your IP on your products that you just segmented. And then you define all the licenses or IP rulings about it. So are you now also pleading that you have different laws applicable to all these IP layers and it should be like a bit more concise on an international level?
I think what I'm advocating, that's a great question. So let's break it down. So what you just described is what very good lawyers do, and that is they think about, okay, I have this product, and I'm going to think about what goes into this and how it's done. What I'm suggesting is that you need to think about this as what this really is, and what ultimately the person who's buying it or using it is going to get from you. It might very well be that you think about products and different forms of it, so it's not just all focused on what you're doing. So my example would be like that car, like that Tesla car that had all these different suppliers and supply chain. Think about what they're dealing with. They're dealing with to get efficiency. And admittedly, in a very expensive car, but almost all cars now are internationally built across lines and different components. Almost all sophisticated goods come from a variety of suppliers. And what I'm arguing is, if we think about that as all that's going in, my plea is, if we're dealing with transactions that deal with across boundaries, is it would be nice. It would be a good idea, and the boundaries would have to be worked out, but it would be nice to be able to, no more than nice, I think imperative, that we have commercial principles that could apply, so that when I'm negotiating with you about your product, and we do a deal, and it's laden with all this IP, it would be a good idea, I think, to know that at least some of the rudiments, in terms of an enforceable contract, what might be implied, when I use some common phraseology, what that would mean. Because like I said before, that's not always so clear. You and I, as experienced practitioners, might think we know, and there might be this general body that applies in our industry, but that doesn't necessarily mean anything when it gets into the courtroom or into an arbitration panel. So my plea is, we need to think about commerce just with IP assets, just like we do with other assets. See, I got some comments from already. It's first gropings of artificial intelligence. So you get commentary from around. Yeah.
I think Siri all of a sudden got involved.
Yeah, Siri said, "To heck with this." This guy's harshing my day.
Well, thank you very much.